Good morning, everybody. Welcome to the convention and to this presentation. Today's presentation is just to give you an overview of some of the issues that are important in the horticulture industry from the labour law or employment law, industrial relations law perspective, however you like to call it. What I intend to do is talk of where there have been changes in legislation in the last, say, year and a half, give you just some discuss some topics arising out of some recent cases. Most importantly, the 4-year modern review, which is about reviewing all awards in Australia, which of course includes the Horticulture Award, the Harvest Trail campaign, which is the approach which the Fair Work Ombudsman has taken in looking at piecework in the industry, and lastly, some just touching on some changes to the budget regarding the taxing of backpackers. In terms of legislation, the first area that I just want to touch on is the law of bullying. As you probably are all aware, bullying laws took effect on the 1st of January of last year. Now, it's important to note that the bullying laws basically say that if there is continued conduct which imposes a risk to health and safety of an employee, it's actually broader than that, it's a worker, then that person may make an application to the Fair Work Commission to get an order to stop the bullying. Now, there is an exception in the legislation, and that is that if the business has taken reasonable management action conducted in a reasonable manner, then it is not bullying. Now, there have not been a lot of bullying cases, which is quite interesting because everyone thought that the millions of bullying cases, in the same way that when the unfair dismissal jurisdiction started, there were lots of unfair dismissal claims. Interestingly, the Fair Work Commission has actually been quite resilient in not expanding its jurisdiction and allowing a lot of bullying claims in. For example, when people have made complaints about they feel that they should have been given a different performance rating in their work, the court said, or the commission said, that is not bullying. But what's important for every business in this space, including in the horticulture industry, is that you need to look at how you're going to minimise your risk, to minimise a claim of bullying being brought against you. The first thing is that you should have a policy in place which deals with the bullying laws. So it should set out what the obligations are, and also the process that you will adopt internally in dealing with a complaint. Because what is very important in this space is that the Fair Work Commission has said that I will look at if a bullying complaint has been brought to the Fair Work Commission, I will look at the processes that have been adopted internally to determine what, if any, remedy I should grant to the person who's making a bullying complaint. And often what actually happens in practice in the Fair Work Commission, they're dealt with at the conciliation stage, and they just have asked employers to just go back and do a few extra steps, and that usually resolves the issue. The other part of it, of course, is having the right people that when a complaint is in place to deal with the complaint and know how to process a complaint internally within the business. So make sure that you have the right people that you can turn to get the advice to make sure that if a complaint has arisen, that you deal with it to make sure that to the extent that you can, you avoid or minimise the risk of this matter going to the Fair Work Commission. It's important to note that only people who are currently workers or employees can bring bullying complaints. If someone has left the workplace, they cannot bring a bullying complaint. That really is for the space of the unfair dismissal laws and the general protection laws. The other area which has not actually been introduced as legislation but is still sitting as a bill in Parliament is the Fair Work Amendment Bill. The objective of that bill, as I stated up there, is to actually restrict the operation of leave loading on termination of employment. Now, currently there is a big issue that's happening in the Fair Work Commission and in courts as to whether if an employee's employment is terminated, whether the employee is entitled to be paid their annual leave loading together with the annual leave on termination of employment. The approach generally has been from employers, of course it is not. The side of the unions is, of course, that it is. There have been cases so far in courts, in the courts, which say actually it is, but it is currently actually awaiting a final further decision by the full court of the Federal Court. In fact, the ACTU has brought a claim as part of the 4-year modern review to try and entrench that as an obligation in all awards, including the Horticulture Award. At the moment, the Horticulture Award is silent on that issue. The Fair Work Commissioner said, look, I will not decide this issue about the annual leave loading issue until that full federal court decision is handed down, and then we'll look at it further. The next, sorry, I went too far. The next area is just some cases that are important for the horticulture industry, not just about the horticulture industry, but will impact on the horticulture industry because they are relevant for every employer in Australia. And the first case is the case of Richardson and Oracle, which was a sexual harassment case. Now, I just want to give you a few sort of details about what that case was about because it is quite significant. And what's very important is because of the damages that have been awarded by the full court of the federal court, and that has now set the standard of what the appropriate damages are in sexual harassment cases. That is $100,000 for sort of the pain and suffering that an employee has suffered in being sexually harassed. Now, what had happened in this case, it was about sexual harassment that lasted over a 9-month period, directed to a female manager by, in fact, her male junior. And he would actually say things like, gosh, it's a good thing you didn't come out with me last night, because if I was drinking with you, we would wind up in the corner and I'd have my arms around you, kissing you. He made comments about her legs and the skirt that she was wearing. He would refer to going away and having a dirty weekend. And he said, look, I know you love me, you know you want me. There was more, that's just the tip of the iceberg. Now, in fact, what had happened, the woman had brought a sexual harassment claim and had been investigated by the employees of Oracle Corporation, a very large corporation. They actually found that the discrimination, the sexual harassment had occurred. She wasn't really satisfied with the outcome. She proceeded to a court. When he went to the court at first instance, the court found that the employee who was sexually harassing embarked on a systematic course of conduct that is fairly described as sexual harassment. And what is important is that the court also said that the employer is liable for the conduct of the employee that was engaging in the sexual harassment, because the law in this area says that unless an employer takes reasonable precautions to prevent the discrimination or the sexual harassment happening, they are also engaging in the discrimination or the sexual harassment. And what that means from a practical perspective is that at the very minimum, every business must have a discrimination harassment policy in operation. That's absolutely key. The second thing is it depends on the size of the business. Levels of training must operate within the business. So they're saying a small business doesn't need to sort of conduct the training levels that a big, say, corporation does, but there must be sort of updates and developments about it. And the other issue is that, when you need to have processes in place to investigate complaints internally and objectively when those complaints or issues arise. Now, what had happened is, although the court found that the female employee or the manager had been discriminated against, it actually only awarded her $18,000 in compensation for all up in terms of the discrimination, for the hurt feelings, the distress, the humiliation, and for any losses of income. On appeal, in fact, that increased to $130,000. And the reason that happened, there was no new facts presented, nothing. But what had actually happened is the full court of the federal court did say that that really the laws had sort of remained stagnant for 30 years, and that the laws had not developed with the times and the changes in society, and that having regard to the nature, the extent of the injuries of the individual and the prevailing community standards, the compensation level awarded by the court was inadequate, although it did acknowledge that the criteria that the court used at the lower level were the criteria that were being applied at the time. It said further, community standards now accord a higher value to compensation for pain and suffering and loss of enjoyment of life than before in personal injury cases arising from bullying, and it should be the same in sexual harassment claims. So it is important to be aware that when claims of this nature arise, the risk is much higher in terms of what your liability is than it was previously. The next case I want to touch on is just the case called the Mitterlo Group, and that arose because Mitterlo applied to actually have an enterprise agreement approved by the Fair Work Commission, and it used a horticulture award as the base award for the purpose of determining the better off overall test, which is the test that's used for determining whether an award should be approved or not. In fact, the National Union of Workers came to the hearing and say the horticulture award is not relevant. What is relevant is a storage services award. And the reason that occurred, because on the facts of the case, it was actually just in respect of a packing site that was off the farm site. And there were also a lot of company structures. Now, the decision was appealed to a full bench of the Fair Work Commission. It said, having regard to the construction of the coverage clause of the horticulture award, the decision was right. Two things are now important in this context. It did also say that as part of the 4-year modern review, which is happening now and the horticulture industry is involved in, I actually am representing a number of players in the horticulture industry in the 4-year review, that an opportunity now has arisen to actually apply to vary the coverage clause to try and bring the off-site packing sheds back into the horticulture award. The other thing that's become apparent that I've become aware of is that now the NUW is actually turning up to farms basically saying that the AEW is giving them approval to actually sort of come in and inspect and do a variety of things. The reality is that the NUW doesn't have coverage, and if they try and exercise what is known as right of entry, demand to see first of all, the entry permits, because if you just let them in voluntarily, then it's not covered by the right of entry laws. And so give me evidence of the proof that you can represent any of the workers here. They can't generally represent people in the horticulture industry on farm sites. The last case which I have got there, Roberts and A1 Scaffold, concerns a provision in the Fair Work Act. When employers are basically sued for breaches of awards and enterprise agreements, there is a provision in there which, if someone who effectively is knowingly concerned in a contravention of a breach of an award or an enterprise agreement, can also be held liable as if that person was the wrongdoer. It's a bit like that other case I just mentioned before about the sexual harassment case, where the employer is liable for the conduct of the employee who's discriminating against another employer. Now, the courts are taking a very liberal approach to this provision, so they're actually saying that directors can also be liable who are actually sort of actively involved in the contravention, even though the business is owned by a company that is not it's not just a sole trader or partnership, so they're actually also finding directors liable. And what actually even happened in that case of Roberts is that the company had gone under. There were Phoenix arrangements, and the employees or the ombudsman who actually brought these prosecutions knew that they would never get the money from the company, so they did pursue the directors, and the directors are there, and they've been found to be personally liable, and they will get the money off the directors. I've mentioned a couple of times the 4-year modern review. This is critical for the industry of Australia, all awards, but even so, just as much for the horticulture industry. It commenced in December. We've been there. I've been representing people in the horticulture industry from December 2013. It's a slow process where basically the Commission is required to look at each award and determine whether it meets what is known as the modern awards objective. The approach that's been taken is that it's determined matters which are considered to be common issues. That includes annual leave, casual employment, part-time employment, a number of other issues as well. And then what it's also done is it's looking at each award, and it is varying each award to deal with updating it in terms of language and style, plus also dealing with issues which it say need to be varied to deal with the modern awards objective. At the moment, what's happened is it has actually removed the accident pay provisions and the district allowance provisions from all modern awards. It also has removed, for people who are particularly from New South Wales, because this is where it's important, the maintenance of the old high inflated redundancy provisions that used to exist in New South Wales and were continued by virtue of some of transitional legislation from the awards as well. The other part that's important too is if you looked at your horticulture award, what it did say that if there is a transfer of employment, the new employer must recognise the annual leave entitlement of the employer when they're transferred from the old employer. Now, that actually was in conflict with the legislation because the legislation gave the new employer the option. So they've actually removed it from as an obligation from the award, and it now reflects simply what's in the legislation, that is that the new employee can agree to recognise the service but is not bound to recognise the annual leave service. The other issue that's recently just been determined, that's in the last week or so, actually I think it was about the 11th of June, the decision was handed down on annual leave. What's important from, there's a lot of information there, but I'm not going to go through all the details, but what will be important for everyone here is that very shortly there will be in the Horticulture Award an ability to cash out annual leave by agreement. There are a number of restrictions in place on how you can do it. Till recently, you were prohibited from doing it because it wasn't in the award. You could only do it if you actually had an enterprise agreement in place which allowed you to do it. Now, the Horticulture Award, as with every other award, will have a standard cashing out provision for annual leave. So I know, and many people know, that whether it's the business needs, often employees do come and say, can I actually just be paid my annual leave? I don't necessarily want to go on annual leave. Now there's a process for that to happen. It must be in writing, of course. It's a requirement that you can only take 2 weeks per year by cashing out, and that there must, at least 4 weeks must remain. The other issues that have arisen is that there is now going to be a standard clause on excessive annual leave. That is about giving a direction to an employee to take annual leave when they've got a lot of annual leave accrued. However, in that process, a minimum of 8 weeks must have accrued. There must be genuine attempts to try and reach agreement, and at least 6 weeks of annual leave must remain after the annual leave is taken. Some of the other issues on the annual leave front, as they affect horticulture, include now, there always was a provision in there about allowing paid leave in advance. For example, if you have an annual close down and the employee doesn't have enough annual leave accrual, you could agree with them, for example, that they take that annual leave, and of course, if, for example, they leave or the employment is terminated before the accrual is made up, you can deduct it from what is paid on termination of employment. So that's there, but there's going to be some new tightening of the laws. A new issue which will be relevant is that if you pay your employees by electronic funds transfer, that you'll be able to continue the process during the annual leave period, so you won't actually have to pay them the annual leave when they take annual leave in advance of it. You can just pay it as per the cycle. And the other issues which are still to be determined are the annual leave loading, which I mentioned earlier, and also they are considering a process where you'll be able to have a purchase leave arrangement whereby what you do is pay someone slightly less each week, but they'll get more annual leave accrued to be offset for the lesser payment. Of these issues, I've got outstanding issues. Family and domestic violence leave is going to be important. That's an answer to your claim. The really big issues in our industry are issues to do with casual and part-time employment, particularly casual employment, because we do know that we are very much a seasonal industry, and casual employment is probably the main form of employment in the industry. The first thing that is looking to be achieved is to introduce, not just in the horticulture award, but across every award in Australia, is a casual conversion clause, which will mean effectively that either after 6 months or 12 months of employment, an employee who you employ regularly and systematically, say regularly every 38 hours per week or so, will have a right to apply to become, if they work say 38 hours a week, to become full-time employees. If they work say 25 hours a week on a regular basis, for example, to become part-time employees. Now, this is an issue which of course is very important in this industry, and we haven't seen the full details of it, but there is a process and we are looking to make sure that that doesn't get introduced. The other two critical issues are they want to introduce minimum engagements for casuals. Again, the Horticulture Award, does not have a minimum engagement of casuals. You can employ them for 1 hour on a day. Most awards in other industries have a 3-hour minimum engagement. Ours is quite unique because of the nature of the industry. The ACT wants to increase it to 4 hours across the industry. This is very big for this industry. The horticulture industry is involved. We're actively involved in talking with, the Australian Chamber of Commerce and Industry and the Australian Industry Group to actually, and with a whole lot of other employers, to try and run a concerted campaign to make sure that these changes don't take place. The other issue is that the union does want to introduce a clause which entitles casual employees to be paid overtime after their sort of 38 hours per week or average of that over a cycle. Again, it's not in the award. Let's, we have to make sure that that doesn't get introduced. So if you are asked at any stage to participate in a survey to get information to try and challenge this, I would request that you do participate in that survey. That is in the process of being developed right now. Your information and your input will actually assist with that process in challenging what the unions and the ACT are trying to do. The last area I just want to touch on is actually one more, but after that we're very quick, is the Harvest Trail campaign. Now, the Harvest Trail campaign was what the Fair Work Ombudsman described as a process where they were turning up to sites looking at how piece workers were working in the industry, because there is a perception out there that piece workers are not being paid right or being underpaid, or the rate set for the piece worker rate is too low. Now, of course, you see the unions always try and argue that. What actually happened was that I, together with some other members of the horticulture industry, did meet with the Fair Work Ombudsman to discuss this issue. We made it very clear, and they have agreed that you don't have a standard way to work out the irrelevant piece rate. That is, you can't work out a piece rate across the industry. It is literally site-based, depending on all the facts and circumstances, and they acknowledge that. But I must say that, if for any reason that your current employees are being paid well below their wardrobe because they're not very good at their piecework standards, you will have to provide evidence that, why they're being paid so low. And just lastly, I just want to touch on the fact that there's a proposal to remove the tax-free threshold for backpackers on the 417 visas. Thank you, everybody. If there's any questions, I'm happy to take any quick questions.